A closed corporation. So a closed corporation is a corporation in which the stock is held in a few hands or in a few families in which stock is not at all or only rarely dealt in buying and selling. So in simple words, it means that it is not open to the public. And it's like a small private club where only a few trusted members can join and make decisions. This is perfect for family businesses or close friends who wants to keep things private and simple. Under Section 95, there are mandatory provisions in the Articles of Incorporation of a closed corporation. These are in addition to the items provided for in Section 13 of the Revised Corporation Code of the Philippines. Number 1 is all of its issued stock, exclusive of treasury shares, shall be held liable of record by not more than a specified number of persons, not exceeding 20. Next is all of its issued stock shall be subject to one or more restrictions on transfer permitted by the code. So this just means that special rules to sell the share, there are special rules to sell the share. And this will be further explained in Section 97. Number 2 is any of its stock shall not be listed in any stock exchange or offered to the public. And all of the features that I had just shared, which is provided by this section, must be present. So, for example, even if you did not exceed 20, let's say there's only 15 shareholders. Even if you only have that amount of person, if you did not comply with the mandatory provisions, then you're not considered a closed corporation. Other considerations is that 2/3 of the voting stock of a corporation is owned or controlled by another corporation, which does not fall within the definition of a closed corporation, then the former is not considered a closed corporation. The reasoning for this is because a closed corporation is supposed to be small and privately controlled by its owners. If a bigger corporation, which is not a closed corporation or what is a regular corporation, owns most of the shares, it takes away that independence. Another consideration is corporations such as mining or oil, stock exchange, bank, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest are not allowed to be incorporated as a closed corporation. That is because these companies handle public money or provide essential services. They need to be open and transparent to the public and the government. Also, if something goes wrong in these industries, it could affect a lot of people. More stockholders and regulations help prevent abuse of power or mismanagement. Next is Section 96. So Section 96 includes the permissible provisions in the Articles of Incorporation of a closed corporation. So previously in Section 95, it includes the mandatory provisions. But here in Section 96, these are provisions that we can add to the Articles of Incorporation but are not mandatory. Number 1 is classification of shares or rights and the qualifications for owning or holding the same and restrictions on their transferees as may be stated therein. Number 2 is classification of directors into 2 or more classes, each of whom may be voted for and elected solely by a particular class of stock. For example, Class A stockholders can vote only for Class A directors and Class B stockholders can only vote for Class B directors. Number 3 is agreed quorum or voting requirements in meetings of stockholders or directors than those provided in the Revised Corporation Code of the Philippines. So in the Revised Corporation Code, meeting of directors majority. But in closed corporation, you can specify, for example, 80% or 90% would be quoted. Fourth is, the Articles of Incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by a board of directors. So in a closed corporation, the stockholders can choose to run the business themselves instead of having a board of directors. Since there are only a few of them, they'll manage the company directly. They don't need a separate group of directors to make decisions. This way, the stockholders are both the owners and the managers. Fifth is the articles of incorporation may likewise provide that all officers or employees or that specified officers or employees shall be elected or appointed by the stockholders instead of by the board of directors. So in a closed corporation, the owners can decide who the officers or employees will be. Instead of the board of directors choosing these people, the stockholders can make the decisions themselves. Next is the conditions on the transfer of shares, which is Section 97. Number 1 is restrictions on the right to transfer shares must appear in the articles of incorporation and in the bylaws as well as the certificate of stock. Otherwise, they shall not be binding on any purchaser thereof in good faith. Closed corporations often involve family members or close friends, so restrictions ensure that shares can't be sold to outsiders, which might bring in people who don't share the same goals or values. By requiring transfer conditions to be in the articles of incorporation, bylaws, and stock certificates, it guarantees that all stockholders and potential buyers or third persons are aware of the rules. This prevents misunderstandings and ensures that no one can claim ignorance. 2 is they shall not be more onerous than granting the existing stockholders or the corporation. The option to purchase the shares of the transferee stockholders with such reasonable terms, conditions, or periods stated therein. So this rule ensures that share transfer restrictions are fair and not overly strict. It protects stockholder rights, maintains trust, and ensures that when someone wants to sell their shares, the process is reasonable for everyone involved. Now, right of first refusal. So the corporation or the stockholders have the right of refusal. That is, the stockholder who wants to sell his shares must first offer it either to the corporation or to the other existing stockholders. If the corporation or the existing stockholders fail to exercise the option within a period stated, the transferring stockholder may sell his shares to any third person. The period of 1 month is deemed sufficient for the corporation or the stockholders to signify their desire to buy the shares of the stock being offered for sale by any stockholder. So in a closed corporation, the right of first refusal means that if a stockholder wants to sell their shares, they must first offer them to the corporation or the other stockholders before selling to an outsider. Now, why is this important? It prevents outsiders from buying shares without giving the current stockholders a chance to buy them first, and protects the company since the corporation gets a chance to keep shares in the hands of people they trust. Next is Section 98. So this includes the qualifying conditions in issuance of the shares. First is certificate for such stock conspicuously shows the qualifications of the persons entitled to be holders of record thereof. So to ensure that only qualified individuals can become shareholders, the company's stock certificates would explicitly state these conditions. For instance, the certificate might read, this certificate of stock is issued to subject to the condition that the holder must be a certified public accountant. Next is that the articles of incorporation states the number of persons who are entitled to be stockholders of record, and the certificate for such stock conspicuously states such number. Next, the stock certificate conspicuously shows a restriction on transfer of the corporation stock. Now, what if there are breaches in the qualifying conditions previously mentioned? One is, the transferee is conclusively presumed to have notice of the restriction or condition, and therefore he is not allowed to prove lack of notice even if such is the fact. The corporation cannot be compelled to register, although it may. And at its option, register the transfer of the stock in the name of the transferee. The stock certificate clearly states that there are restrictions on who can own the stock. When you buy the stock, you're presumed to have seen this restriction, even if you did not actually read it. So as a buyer, or the third person in the party, you cannot force the company to register the stock in your name. The company can choose whether or not to do it. Next, the transfer, however, shall be binding upon the corporation, notwithstanding such conclusive presumption. where it has been consented to by all the stockholders of the closed corporation. Or if the closed corporation has amended its articles of incorporation. This is just saying that even though the buyer might not know about the restriction, the sale can still be valid if the family agrees or changes the rules.
Hello, I'm Angela Sanchez, and I will begin the discussion of Section 99 to Section 102 of the Revised Corporation Code of the Philippines. So, Section 99 is about the agreements by stockholders, and it is divided into 5 major concepts. First, agreements made by all stockholders before incorporation remain valid even after the corporation is formed, as long as they are consistent with the articles of incorporation. Second, it allows the stockholders to agree on how their shares will be voted, but it must be signed by 2 or more stockholders. Third, prevents agreements from being invalidated on the grounds of creating a partnership among the stockholders. Fourth, permits agreement regarding the corporation's business and affairs, but they cannot restrict the board of directors' powers. And last is that it hosts stockholders actively involved in management to strict fiduciary duties to each other and personal liability for corporate torts. So the case point of this section 99 is that it focuses on the validity and enforceability of agreements made by the stockholders before a corporation is formed. These agreements are considered binding even after the corporation is established, as long as they don't contradict the corporation's official documents or the articles of incorporation. So for example, imagine you and your friend is starting a small business. Before you officially register the business, you all agree on how to split the profits, how to make decisions, and who will be responsible for certain tasks. Section 99 says that these agreements are still valid even after you open your business. But there must be important considerations that we need to take account. First, consistency with the articles of incorporation. Like I said, the agreement must be consistent with the corporation's official document. If there's a conflict, then the articles of incorporation will be followed. Next, voting rights or the stockholders can agree on how their shares will be voted, ensuring their wishes are respected. Last, we have partnership versus corporation. This section clarifies that these agreements don't create a partnership among the stockholders and they remain separate from the corporation. Next section is 100, and it is about when a board meeting is unnecessary or improperly held. So in this section, it outlines the situations where actions taken by directors of a closed corporation without a proper meeting are still valid. First, if all directors consent in writing. Second, if all stockholders know about the action and don't object. Third, if directors regularly take informal action with the stockholder agreement. Fourth, if all directors know about the action and don't object. 5. It ratifies actions taken at meeting without proper call or notice if a director doesn't object promptly. So the key point of this section is that it addresses the relationship between stockholder agreements and the board of directors. While stockholders can agree on how the corporation's business should be run, their agreements cannot limit the power of the directors. The board is still responsible for making the day-to-day decisions. So for example, let's say you and your friends agree that you always consult each other before making a major business decisions. However, Section 99 says that the board of directors still has the ultimate authority to make decisions even if it goes against the original agreement. Here are the important considerations we must take account. First, board's authority. The board of directors retains its powers to manage a corporation even if there are stockholders' agreement. Second, balance of power. This section strikes a balance between the interests of the stockholders and the need to effective corporate governance. Next is Section 101, and it is about the preemptive right in the closed corporation. It focuses on the extension of the preemptive right of the stockholders in closed corporations to all stock issued, including treasury shares unless the articles of incorporation specify otherwise. So the key point here is that it focuses on stockholders who are actively involved in managing the corporation. These stockholders have a special responsibility to be honest and fair to each other, acting in the best of interest of the corporation. They're also personally liable for any harm caused by the corporation unless the corporation has insurance. So, for example, if you're one of your friends actively running the business, you can secretly use the business money for your own personal gain. You also have to be careful not to make any mistakes that could hurt the business because you might be personally liable for that mistakes. And here are the important considerations we must take account. First, fiduciary duty. Stockholders involved in a management owe a high level of trust and loyalty to each other and the corporation. Second, we have personal liability. Stockholders can held personally liable for the corporation's action, especially if they're actively involved in the management. Next is Section 102. It is about the amendment of Articles of Incorporation, and it requires a two-thirds of the vote outstanding of capital stock to amend the Articles of Incorporations that delete, remove, or required by the Title 12 or reduce the quorum or voting requirements. So the key point here is that this section is that it reinforces the importance of acting in good faith and avoiding conflicts of interest for stockholders involved in management. They must be transparent in their dealings and prioritize the corporation's well-being over their own personal gain. So for example, if you're involved in management, you can't use your position to benefit yourself at the expense of the corporation. You also have to disclose any conflict of interest, such as having a personal relationship with a supplier. And here are some important considerations we must take account. First, we have transparency. Stockholders involved in management must be open and honest about their actions and decisions. Second, conflict avoidance. They must avoid situations where their personal interest could conflict with the interests of the corporation. So, in essence, the section 99 to 102 ensure that stockholders in close corporations can make agreements to guide the corporation's operations. But they also emphasize the importance of a board of directors and the need for the stockholders to act ethically and responsibly.
But I think that I will discuss Section 108 to Section 106. So Section 103 is the provision that allows the SEC or the Securities and Exchange Commission to intervene or arbitrate a dispute in case of deadlock. So what is a deadlock? It is when the stockholders or directors is so divided that the votes required for any corporate action cannot be obtained. So this deadlock prevents the business and affairs of the corporation from being conducted to the advantage of the stockholders. Upon legal petition by any stockholders, the Commission by the SEC shall hold the power to arbitrate the dispute. In the event of deadlock, they may first cancel or alter any provision in the Articles of Incorporation, bylaws, or any stockholders' agreement, to cancel, alter, or enjoin any resolution or other act of the corporation or its board of directors, stockholders, or officers. 3. Prohibit any act of the corporation or its board of directors, stockholders, or officers, or other persons party to the action, requiring the purchase of or value of the shares of any stockholders, either by the corporation, regardless of availability of unrestricted leading donors, or by the other shareholders. Kept is the appointment of divisional director. So the second paragraph of this statute will govern. So the provisional director will break the deadlock by casting the deciding vote. All 6 is the dissolving of the corporation, and number 7 is to get other relief as the circumstances emerge. So the second paragraph of Section 103 is about provisional director. A provisional director is a temporary director appointed by the court to resolve a deadlock situation in corporation. So this typically occurs in the requisite stockholders are unable to make decisions due to a split or conflict, preventing the corporation from functioning. So the provisional director's role is usually limited to making the deadlock or managing the corporation's affairs temporarily until the situation is resolved. This division ensures that the corporation can continue to operate even in the case of internal governance conflicts. Section 104 is the last section under Title 12. So this section is about withdrawal as stockholder or dissolution of corporation. Basically, the stockholders has two remedies. Any stockholders of a tourist corporation and compel the corporation to purchase its shares at a fair value, it shall not be less than their par or issue title, provided that the corporation has sufficient assets in its books to cover its debts and liabilities, exclusive of capital stock. Number 2 is that any stockholder of a closed corporation may, by written petition to the Securities and Exchange Commission, compel the dissolution of such corporation whenever any of the directors, officers, or those in control of the corporation is illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial to the corporation or any stockholder, and second is the corporate assets are being misapplied or wasted. Okay, so we are now at Title 3 again, Special Corporation. Chapter 1 of Title 3 again is about educational corporations. So educational corporations are those that provide facilities for teaching or instruction. It engages with public and private schools, or colleges and universities, and are subject to the provisions of special laws and by the general provisions of the code. So as per Section 105, educational corporation shall be governed by special laws and by the general provisions of this code. So these instructions of meaning once recognized by the government as such are mandated by law to be incorporated within 90 days under the provision of the Corporation Code, and must first comply with the requirements and procedure laid down thereunder. So their failure to do so could not ruin the educational institution can receive as a corporation. So the educational corporation can be sued. Moving on to Section 106. So it is about the Board of Trustees. So this is for non-stock educational corporation. So the number of trustees shall not be less than 8, no more than 15. And shall be multiples of 5, 10, or 15. So unless otherwise provided in the Articles of Incorporation or the bylaws, the term of the office of the pre-selected trustees shall be studied with 1 year interval. After the trustees describe by themselves that the term of office of 1/5 of their members shall expire and be used. So this is the general rule, unless otherwise provided in the Articles of Incorporation or the bylaws. Trustees elected to fill vacancies shall hold office only for the unexpired period of the particular term. So if the particular term is 3 years, and on the second year he was elected to fill the vacancy, then he shall hold the office for the unexpired term, which is 1 year. So trustees elected subsequently due to the expiration of term shall hold office for 5 years, and a majority of the trustees shall constitute a quorum for the transaction of the business. So for voting purposes, the powers and authority of trustees shall be declared in the bylaws. Super institutions organized as stock corporations, the number and term of directors shall be governed by the provisions and stock alterations. The board of directors shall be the same as an ordinary stock corporation, which is not less than 5 and not more than 15.
So hi there, I'm Renan G. Garati Jr. and I will discuss the sections 107 to 110 of the Revised Corporation Code of the Philippines. So this section primarily pertain to a religious corporations, outlining its classification, formation, and requirements that are necessary for their legal establishments and operation within the country. So what is religious corporations? When we say religious corporations, that is a entity composed entirely by the spiritual persons. So the examples of spiritual persons are bishop, priests, monks, archdeacons, abbots, and many other. So this religious corporation is organized for the furtherance of religion, perpetuating the rights of the church, managing the church-related activities, religious works, and also the properties. So basically, that is a non-profit organization that is incorporated to engage into our religious activities. And it is also important to take note that this is a special corporation that is governed by specific provision found in Section 107 to 140 of the Revised Corporation Code of the Philippines and by the general provision on non-stock corporation insofar is applicable. So it is also important to take note that the special rules prevailed over the general ones, and the religious corporation should not be confused with the non-stock corporation that is intended or that is incorporated to engage in our religious activities or into our religious purposes. So under the Section 107, the Revised Corporation Code of the Philippines, religious corporation can be classified into two main categories. We have the corporation soul and the religious societies. So what is corporation soul? When we say corporation soul, that is a legal entity that can be formed or incorporated by a single person consisting of one member and his successors. Typically, a high-ranking religious leaders such as chief, archbishop, bishop, priest, minister, rabbi, or other presiding elder. So the purpose is to manage and administer the affairs, properties, and temporalities of the religious denomination, sect, or church. On the other hand, religious societies can be formed by two or more persons, having a multiple individual to its governance. And the purpose is somewhat similar to a corporation soul. So basically, the religious societies is a religious organization that incorporates into a corporation. So now let's move on to the section 108 of the Revised Corporation Code of the Philippines. So this section simply outlines the operation of the corporation. So again, it is established for the purpose of managing and administering the affairs, properties, and the temporalities of the religious denomination, sect, or church. So the corporation soul is formed by the religious leader who act as a trustees. So this arrangement allows the religious leader to manage and hold the property in trust for their religious organization. So the common example of this is the Roman Catholic Church, where the dioceses are managed by the bishop who acts as a corporation. So when we say diocese, that is the territorial area in which the bishop have the authority, or that is the territorial area administered by the bishop. So another example is the Iglesia Ni Cristo, in which the executive minister serves as a corporation soul, managing the property and the affairs of the organization. So moving on to the section 109 of the Revised Corporation Code of the Philippines. So it seems to say that in order to become a corporation soul, the religious leader must submit the verified articles of incorporation to the Securities and Exchange Commission. So the following must be included in the articles of incorporation. You must read the presentation now for the exact words since it's coded out, and I'm going to summarize and I'm going to make it short now. So first is the confirmation with their positions within the religious denomination. For example, that he is a chief, bishop, rabbi, priest, minister, or any other positions, and he desires to become a corporation soul. So that must be included in the articles of corporation. Second, the assurance that creating a corporation soul is not prohibited to the rules and regulations and the discipline of a religious denomination. Third is description of a territorial jurisdiction in which they have the authority, as well as it must be formally describes the responsibilities of the religious leader in managing and administering the affairs, the properties of our religious denomination, with it becomes a corporation. So it is the procedures of appointing new religious leaders to a vacant position. So in case of the death or incapacity of the religious leaders or any other circumstance that makes the position vacant, it must be indicated, or it must be stated in the articles of incorporation how it is to be filled. If there is if there is a successor who can fill the vacancy or any other race. So fifth is the it must be stated in the articles of incorporation the location of the principal counties, and it must be within the Philippines. So take note that articles must include other provisions not contrary to law for the regulations of the corporation or of the corporate affairs. So finally, let's move on to the sections 110 of the Revised Corporation Code of the Philippines. So this section outlines the process for a religious leader to establish a corporation. So submitting to the SEC by the religious leader the verified articles of incorporations along with the proof of authorization, certificate of elections, or the letter of appointment proving the positions of the religious leader. These documents must be certified by the notary public to ensure its authenticity. So once this document is filed with the SEC, the religious leader automatically become a corporation sold, and all the properties, temporalities, and estate that are previously managed by them are held in trust for the benefit of the religious denominations, sect, or church, and also the associated institutions like schools, hospitals, cemetery, and etc. So please take note that the religious denomination were already incorporated as a corporation soul at the time of their submission of articles of incorporation. So it is not necessary for them to wait, or it is not necessary for them the approval of the SEC to their articles of incorporation for them to become a corporation solely. So that's all for my part.
I'm Andrea Lozano, and I will discuss the section 111 to 114 of the Revised Corporation Code of the Philippines. So in section 111, it's about the acquisition and alienation of property. So, as previously discussed by my fellow members, a corporation soul is a type of a religious corporation formed by the head of a religious denomination or church. So, in this section, it outlines the property rights and responsibilities of a corporation soul. So, first is the acquisition. So, a corporation soul can acquire a real estate and personal property for its religious, charitable, benevolent, or educational purposes. So, it can also receive bequests or gifts for this purpose. So, next is alienation. The corporation soul can sell or mortgage a real property only with a court order from the Regional Trial Court or RTC and the province where the property is located. So this requires the proof of public notice and demonstration that the sale or mortgage is in the corporation's best interest. However, the religious organization internal rules regulate such transaction for intervention. It is not necessary. So example, imagine na you are in the debate team of your school organization. So and the team wants to buy a new set of microphones. So they can use the club's money to buy them. But if they want to sell their old or broken microphones, they might need to get the permission from the school principal first. So next is the section 112, which is about the filling of vacancies. So this section addresses the succession of leadership within a corporation soul. So first is succession. When the head of a corporation soul is replaced, the successor automatically becomes the new corporation soul upon filling a copy of their commission, certificate of election, or letter of appointment with the SEC. So next is vacancy. During the vacancy in the head of position, the persons authorized by the religious organization rules manage the corporation. So example na, if your debate's president graduates and leaves, the vice presidents automatically pick the president. So they need to tell the school na their now in charge. If there's no vice president, then the club's advisor might take over until a new president is elected. So next is section 138, and this is about the dissolution. So this section outlines the process for a voluntary dissolution of a corporation sold. So first is the procedure. A corporation sold can be dissolved voluntarily by filling a verified declaration of dissolution with the SEC. So this declaration must include the corporation named resolved for dissolution, authorization from the nomination, and the names of those supervising the winding up process. So next is we have the effect. Upon approval by the SEC, the corporation ceases to operate except for the purpose of the winding up its affair. So example, if your debate team decides to disband, they need to tell the school that they're closing down. So they might decide to give their equipment to another club or sell it to raise money for a good cause. So next is we have the section 148, which is about religious societies. So this section addresses the incorporation of religious societies, orders, dioceses, synods, or district organization. So first is eligibility. Any religious societies, order, dioceses, or synod, or district organization can incorporate provided it is not forbidden by the competent authority or the consultation rules, regulations, or disciplines of the religious denomination, sect, or church of which is a part of. So next is procedure. So incorporation requires a written consent or affirmative vote of at least 2/3 of the organization members. So articles of incorporation must be filed with the SEC, verified by the president, elder, secretary, or clerk of the organization. So last is we have the content. So the article of incorporation must state the organization religious affiliation. So the consent of at least is 2/3 of its members. So the absence of any prohibition by competent authority, the organization desire to incorporate the location of the principal office and the names, nationalities, and residents, addresses of the trustees. Example, if a group of students wants to start a new club, they need to get permission from the school and get enough students to agree to join. So they also need to tell the school who will be the president and other officer of the club. So the section 111 to 114 are important because they help religious organizations manage their affairs and make sure they're following the law. So they're like the rule of the game. So making sure everyone plays fair and that the organization is run in a way that benefits everyone involved.